folks. You're with Tacitus today, your pushback channel, and thank you for joining this audio live stream. In this essay, I'd like to talk about this incredible success rate of human rights lawyers and the state of judicial activism, and sort of combine that, if you like, under one umbrella to talk about the wider activist legal fraternity. Now, I'll just start with it's a couple of, or a few actually, legal cases out of Britain, or one in Britain and two in the United States. In fact, one in Australia as well. Now, as soon as I hear the decision that the court has made, I know without even needing to look that that decision was made by an activist judge. Now, just think about this for a minute. When a decision's made and you look at judicial decisions made and you look at it, like as in it's reported in the media and so on, you shouldn't know the political affiliation of the judge. It would make no difference, because every judge swears an oath to uphold the law and the Constitution and interpret the law and assess the facts. And so that's the oath that they take, certainly in most jurisdictions. And it's been hitherto, it's been pretty much the expectation that those sort of judicial decisions would be any judicial decision would be based on the law and the facts and the evidence and so on. But that's simply not the case. Now, I can look at any decision, judicial decision, well, not any, but I can look at most judicial decisions now, and I can say, without even needing to look at the names of the judge or even the details of the case, just the headline of the case, the subject matter, if you like, of the case, I can tell straight away if it's a constitutionalist judge, that is, someone who relies on the facts, the law and the evidence, the tested evidence, and an activist judge. I know straight away. Now, I shouldn't be able to do that. And this is, to me, a savage, a terrible, a withering indictment of what's become of our legal system across the Western world, not just in Australia, but everywhere across the Western world, Canada too. The activist nature of judicial decisions. Now, as the ratio of judges is tilting heavily in favour of activists over constitutionalists or legalists, if you want to call it that, then we're going to see more of this until the law and the practice of law jurisprudence resembles nothing more than a toy or a plaything that the globalists can manipulate and use to push their agenda, to squash opposition and crush dissenting voices and so on. So now this one case that I looked at in the States, I looked at that's an activist judge. Straight away I knew it. Again, before any details. So sure enough, I go online and find that the judge is this is in the US, is appointed by a Democrat administration, and that he's had a background working with NGOs, civil rights groups, legal aid, the classic activist background. Now, we have to sort of consider the determination of the political class, in this case the Democrats, but the political class to purposefully and willfully and knowingly put activist judges into in this case appointments for life, to put activist judges into the position of making legal decisions. And in the higher courts, these decisions have great import in terms of precedent and how they're used by other subsequent legal cases that cite well in the decision of Smith versus Jones and so on. So they can use this. So if they can use the activism of the judge as then a precedent in subsequent cases, which the left and the globalists and the NGOs do very energetically. So anyway, this judge is a classic activist. So the politicians are appointing these judges. I didn't realize it sort of went back quite as far as this, that really these activist judges were being appointed. You could see it you could see it happening in the second term of Bill Clinton's presidency. So, in the late 90s, you could see it sort of not so much in the first term, but definitely in the second term. And like he appointed the first lesbian as the Attorney General, which is, again, an activist flag waving exercise in itself. There were a few activists were getting in even during the George Bush year, not that many, but and then by the time Barack Obama came in, it was full on. It was just absolutely hysterical. I'd say 9 of every 10 judicial appointments, if not more than that, were activist judicial officers, activist judges being appointed, and you could see they were searching for activists. Okay, we've got another judgeship coming up here to fill. Can anyone give me the names of the most prominent hysterical activists here? Because we want to appoint one of them to a judgeship. And some of these people were appointing, junior lawyer clerks, two-bit lawyers from NGOs and so on were being given judgeships. So anyway, that's the activism of appointing activist judges. But you or me or the next person, we should know when a judge makes a decision, we should know or feel confident that the judge, again, used the law, the Constitution, the evidence, and so on. But we've passed that now. And that most judges that around are activists. It's happening in Australia as well. And, there's a judge recently in Australia that again, appointed by the equivalent of a Democrat administration, a climate change activist had been arrested for causing some sort of mayhem and being brought into court. And the judge just let them, even congratulated the activist. Oh, you're doing great work there, Billy Bob, and wow, I admire your courage. Off you go then. You're not guilty, and no charge will be recorded, and but you have to pay a $50 fine. And that very same day, that guy was out demonstrating again, secure in the knowledge that the justice system was never going to hold him accountable for what he was doing, because his activism is approved by the globalist activist class. So now the second part of this essay was I was looking at an NGO website where they were claiming that their human rights lawyers have an incredibly high win record, like 98% winning record now. And even where they're not winning, they're then subsequently winning on appeal or in a Supreme Court type appeal and so on. So they've got, in effect, when you crunch the numbers, they've in effect got 100% success rate. 100%. I mean, is that even possible anywhere in any jurisdiction under any circumstances? Even the Chinese Communist government only gets 98.5% success rate. But these human rights laws operating in the West, in Australia and Britain, America, Canada, and so on, they're getting in effect, again, given the appeals that they lodge, 100% success rate. I mean, holy fuck, that is like, wow, that is impressive. Now, I then went and looked around for the highest profile lawyers I could find, the ones that are considered to be, absolutely expert in their field. These are the top flight lawyers. These are the guys pulling, millions of dollars a year because they're so good. Now, you see, their success rate is high 70s. Say let's just round the numbers off and say 80% success rate. Now, not only are they getting that this is in typically real courts where there are juries and that sort of thing, so it's not judge only, but or some of them are, but they're also able to get they're able to pick their cases, these people. So just going online, looking at a couple of sort of interviews or comments these people have made, these lawyers have made in public, is they only pick cases where they think they've got a really good chance of winning, but they still only get 80% hit rate. Now, these are top flight lawyers. These aren't NGO, nose ring, pink-haired lesbian flunkies. These are the top flight guys. They're considered experts of the experts. When governments aren't sure, and when the multinational companies need a legal opinion, these are the guys that are going to. They're the gurus in their particular legal field, which could be corporate law or whatever it is. They're not into human rights. So these are the guys who, and they're expert at the cross-examination and production of evidence, the filing of documents. These guys know their shit. I mean, their clerks and their flunkies and so on are also the top flight people, the very brightest minds, legal minds, or aspiring legal minds go to work for these guys, or in the law practices these guys are in, because this is where, if you want to become expert in your field and learn how to effectively do all the heavy lifting for winning legal cases, this is where you learn. This is where you learn your craft. So they get 80%. But these human rights lawyers who have no training, no professional discipline, and they're pink-haired with their nose rings and their earrings and their body piercings and so on, they're getting, in effect, 100% success rate in the human rights field. Wow. I mean, wow is the only thing I can think of. Now, they're in cases that have been heard and decided and so on, you can actually get to see online their filings, so that the documents that they file, which is effectively the evidence they're going to present to the court on their case. And say it might be, the one I looked at just recently was someone that arrived in a Western country illegally. They made numerous false claims, all with the help of these human rights lawyers, by the way, and NGO activists and the like. They had made numerous false claims, and they were due to be deported because they'd committed a murder or some serious crime, or multiple serious crimes. They're going to be deported back to the third world country they came from. And yet these lawyers, these human rights lawyers, who are really just untrained activist kids, they're placard waving punks. That's all they are. They're not professional kick-ass lawyers, not by a long stretch. But they're able to win these cases. So I looked at the documents they filed, and it's so amateurish. Now, I've got some understanding. I've filed many court documents over the years. I've had to write them and fill them out and file them and go through the whole process and so on. So I've got some understanding of these things. And I remember sort of my time writing and rewriting and redoing the documents to be filed, of gathering the evidence, of appending it, of doing making it so it could be very easily and clearly referenced. So I could in court I could say, if I can assist the court by drawing Your Honour's attention to evidence exhibit, number this, page 10, paragraph 4, paragraph beginning, Billy Bob said, that sort of stuff, or the document pending where the department stamped this document, and I attach the document here stamped by the department of such and such as exhibit so and so, which if I can assist the court can be found, that sort of thing. So I've been through all that. I know how that works and how it's done. And I remember rewriting and redoing and these documents so it would be crisp, clear, concise, and making sure the judge had all the relevant information upon which to base a legal decision based on the fucking law and due legal process and so on. That was my silly understanding of how it all should work. But anyway, that's now I look at the documents that are filed by these two-bit amateur fucking lawyers, and I'm looking through the document filing, and I think, holy fuck, if I had a first-year law student come to me and say, this is what I'm going to put up, I'd say, you've got to be kidding me. There is no fucking way I'm going to let you put that document up to the court. But here it is. sloppy work, the order of appending didn't match the order that was written up. It looked like it was written by a semi-literate student with minimal understanding of the law or of judicial process, and there were vague assertions being made about the evidence or the situation. Even ridiculous things like I've heard through our channels that the person may be in danger from forces that may exist in an area that may be and vague and just absolute bullshit. And you can't bring those sort of things into a court. If you want to make a claim, you have to produce evidence. And if you say, well, there are activists, that there are murderers operating here which may kill my for example, may kill my client if he goes back to country X. You have to be able to produce some sort of evidence, like local police reports that make that claim. Now, in some cases where evidence is produced, where it is from the area, and it's in a foreign language, and it's not even interpreted, it isn't rewritten in English, and so this two-bit pink-haired lesbian nose-ringed lawyer can say, covered in tattoos, can say, "Oh, this is the police report, and it says this." Well, can we have a legally accredited interpreter? Interpret this. Oh, I've been told it does. That sort of stuff's inadmissible. Now, what's happening here is that the evidence bar that these activist NGO human rights lawyers, the evidence bar they must meet is so low that a one-year-old child could go into court and win the case. It's that low. The evidence bar is that low that they need. And none of the judicial, due legal process, none of that due legal process that should be basic and apply to all parties, none of that applies to them. So they can miss filing dates. They can file the wrong documents. They can turn up with the shoddiest. What one pink-haired lawyer, the alleged lawyer can put the brief together, the legal documents for the case, and then go off to wherever, go on some international junket, and they'll just appoint another green-haired, punk kid to come in and then argue the case. Now, there's a few cases you can see online, and not many, but there's a few. And again, you're looking at an early post-pubescent uni student type girl, and who has no, if any experience at all going into a real court, just a two-bit NGO activist, but with a strange confidence that it doesn't matter what I come into court with. It doesn't matter if I have the evidence. It doesn't matter how piss poor the document presentation is. It doesn't matter if evidence I say I've got I don't have. It doesn't matter, and nothing matters. But I just know I'm going to win this case. That sort of thing. That sort of strange sort of delusional moral self-belief that I can tell any story I want. I can spin any narrative I want, and it doesn't matter. I'm not going to be tested on it. No one's going to ask me difficult questions. The judge just won't hold me to an accountable standard. And they seem to have this confidence going in. Now, how the fuck they know this before they even walk into the court's beyond me. Now, there are a few other things too. If you look at the real lawyers, these big heavy guns, these real heavy dudes, if they want to get an emergency hearing in a court, get a judge to hear a case as an emergency hearing, they've got a real, they don't have much success with that. They've got a low success rate with that. An emergency hearing maybe, I'll instead of waiting 3 months, I'll hear it in 2 weeks, or I'll hear a preliminary case in 2 weeks. They can't get these same day hearings, whereas these human rights groups, they can apply in the morning and on a Sunday, and that very afternoon they can get a judicial determination, a stay or a stoppage or something like that, right at the 11th hour. Now, how the fuck do they do that? They've got an incredible success rate in getting these emergency hearings. So the second thing that they have an astonishing success rate is getting the most activist judges to hear the case. Now, let's say there are 10 judges in this court, and for sake of argument, let's say 5 of the judges are activists and 5 are not. Now, the way the process is meant to work is whatever judge is available that is not hearing a case at the time. The other judges may be in the middle of hearing a case. You're not supposed to take on another case until the previous case is finished, or the case you're working on is finished. If you're a judge, that's kind of how the system is meant to work. But somehow they're able to pluck an activist judge off a case they're already working on, throw them into this, and get it to ask to see a judge in the morning, get a judge straight away, an activist judge appointed, and then get a decision that same fucking day. I mean, wow! Like, no other legal field can you get that sort of speed and that sort of response and that sort of guarantee that you'll get an activist judge to hear the case that will be fully sympathetic and will not hold you to any legal standard. Now, let's suppose you're a judge or I'm a judge, or there's an independent judge that operates on the law. So you've got this pink-haired, nose-ringed lesbian who's really got no legal experience at all, just an NGO hack activist who comes in, and they haven't filed their documents properly, or maybe they haven't probably filed them at all, insofar as you're asking in the morning of a Sunday and getting the case heard on Sunday. So you've straight away you've got to change now the judge has this discretion, by the way, but straight away you've got to change the rules. No, I wouldn't do that. So no, I haven't filed the documents, but it's emergency. We only found out 5 minutes ago. Hey, too bad. Hey, what, the whole legal system has to change just because you don't know what the fuck you're doing? Like there's that attitude. So but let's suppose I accepted and allowed them to do this sort of extra filing of legal documents, which the court accepts as evidence. Well, okay, Ms. Billie Jean, you're saying that your client is in danger if he or she goes back to whichever third world country. What evidence do you have to prove that? Well, we've heard, Your Honour, that there might be and there could be, and it's known to be by. Well, who knows this to be? Oh, well, we don't have time to bring witnesses in. Well, I can't accept that as evidence. Well, you don't have time to bring witnesses in. You've asked for a special hearing. You've asked for an emergency hearing. You've got one. Where's your evidence? Where are your witnesses? Oh, we don't have time. Well, the other side is going to have to produce witnesses to support their case. Why shouldn't you? Why? No. You haven't got the evidence. You haven't fucking got the evidence here. And I'm not going to make. When you've got the evidence, I'm happy to hear your case. But until you've got the evidence, there's nothing. Well, there could be. His life could be in danger. Could be. Prove that it is in danger, and then I'll listen to your case. So in all of these instances, the activist judge is taking vague assertions delivered by a 21-year-old activist, saying that it could be, maybe, might be, don't know, I've heard, and this, and accepting that as fact, and then making a decision based on those assertions. Now, there's a sort of a legal, it's not really, it's an activist legal tenet it's referred to generally as the lingering doubt. And it's not widely used, but they use it in activist courts a lot, where, okay, you've asserted Billy Bob's going to be in danger if he gets sent back for the 3 murders he committed, if he gets deported back to whichever shithole country. You've asserted that he might be in danger. So therefore, even though you can't prove it, even though you've got no evidence, even though you've got nothing to back it up, I'm going to say that there is a lingering doubt that it might be true. Not that it is, or you've proved it, or you get evidence, but it might be true. And therefore, I'm going to give you a stay, and Billy Bob doesn't get deported. That's sort of the type of legal sort of chicanery that's used there. Now, there's also evidence. I mean, you look at some of the other. If I look at some of the other cases, and again, the activist lawyer may say, well, it's known that homosexuals have been thrown off the roof of tall buildings in this country, and Billy Bob is now identifying as homosexual. He wasn't yesterday, but he is today, and therefore he's in danger. Well, again, how do you know Billy Bob's going to be? I mean, he only identified as homosexual yesterday. What is this bullshit? Don't come to fucking my court with crap like this. So there's that. So really, the human rights lawyers are held to a zero standard, or zero burden of proof. They're given emergency hearings in front of activist judges, which is what gives them their effectively 100% win rate. Now, they're generously funded to play these silly games, but the legal system allows them to do it. And the government, any Western government could easily stop this and insist that the burden of proof is equally held by both parties, that the judge can't arbitrarily reduce the burden of proof for the activist pink-haired lesbian. But the governments don't, because they effectively want this to remain in place so that people like Suella Braverman in the UK can say, there's nothing we can do. The courts made this decision. The judges did. Our hands are tied. The law is the law. No one is above the law. And they can trot out that asinine, absurd assertion when, in fact, the human rights people are being held to a completely different standard of law, or an activist globalist standard of law, simply because all this suits the globalist program. You've been with Tacitus today, your Pushback channel. Thank you for listening.